Welcome to This Week in Education Law, where I share up-to-date court decisions from the perspectives of educational administrators and policymakers. This is episode 33. In this episode, I'll introduce a recent case about Texas restricting Explicit and Adult Designated Educational Resources Act. This act was passed by the Texas legislature in 2023. The goal of the act is to protect school children from exposure to material deemed inappropriate. Several provisions of the act are under scrutiny. The first issue is the rating system. The act required library material vendors to rate all materials they have sold or will sell to Texas public schools. The vendors were mandated to submit to the Texas Education Agency a list of materials rated as sexually explicit or sexually relevant. Materials rated as sexually explicit were not to be sold to school districts and were to be removed from library shelves. Materials rated as sexually relevant required written parental consent for use outside the school library. The second issue is the enforcement mechanisms. The Texas Education Agency was authorized to review materials sold by vendors for compliance with the rating system. If the Texas Education Agency determined that a different rating was needed, it would notify the vendor, who then had 60 days to comply with the corrected rating. Non-compliant vendors could be listed on the Texas Education Agency website, and the school district were prohibited from purchasing library materials from those vendors. This act was challenged in court by 2 Texas bookstores, 3 national trade associations, including the Association of American Publisher, Authors Guild, and American Booksellers Association, as well as a legal defense organization, Comic Book Legal Defense Fund. The Court of Appeals for the Fifth Circuit agreed with the lower court's decision to temporarily stop the commissioners of the Texas Education Agency from enforcing the act against the plaintiffs. The court determined that the act likely infringes on the First Amendment rights of book vendors. The act's requirement for vendors to evaluate and classify materials based on sexual content was seen as a form of compelled speech, which means an individual or entity is forced by the government or a governmental body to express, disseminate, or endorse a message, opinion, or stance with which they may disagree or prefer not to articulate. The First Amendment to the U.S. Constitution protects freedom of speech from government interference or regulation. To safeguard the freedom of thought and expression, which are fundamental to a democratic society, government cannot dictate what individuals must say or communicate. In this case, the act compels vendors to engage in expressive activities that may not reflect their personal or professional judgments. The Texas law forced the vendors to make subjective evaluations about what constitutes sexually explicit or sexually relevant materials. Those determinations requires personal, cultural, and contextual judgments that may not align with the vendor's views or interpretations. This goes beyond merely providing factual information about a book and enters the domain of expressing opinions on the appropriateness or explicitness of content, which could be at odds with the vendor's beliefs or preferences. The court also noted that the process of rating materials was neither purely factual nor uncontroversial. The Act's guideline for rating materials involved a complex and discretionary analysis far removed from straightforward factual disclosure. The court emphasized that compelling individuals or entities to express judgments on contentious matters without a clear factual basis infringes upon First Amendment protections against compelled speech. Typically, compelled speech is permissible under the law only in certain narrowly defined circumstances. For example, government employees may be required to communicate certain information as part of their job duties to ensure the smooth operation of government services. This may include public education officials disseminating information about emergency preparedness protocols or updates to educational curricula. In commercial speech, businesses may be compelled to include labels on products that detail ingredient lists, potential allergens, or energy efficiency ratings. In the financial sector, companies may be mandated to disclose interest rates, fees, or other risks associated with certain investments so that the consumers can make informed financial decisions. Those requirements are typically justified on the grounds that they serve a significant public interest, such as safety, health, or environmental protection, by ensuring that consumers have access to critical information that can influence their decisions and behaviors. However, the court determined that the Texas law's requirements diverged from those examples because they require subjective assessments rather than the dissemination of clear factual information. The Act mandated that the book vendors not only identify but also evaluate educational materials based on sexual content, thereby compelling them to express judgments that could be influenced by personal or cultural biases. The requirement goes beyond straightforward factual disclosure. Instead, it compelled vendors to evaluate materials and label them with the government-designated ratings such as sexually explicit or sexually relevant. The court found that this process did not serve a direct public interest or governmental operations in a manner that would justify the compelled speech, particularly given the subjective nature of the ratings and the potential for controversy. Unlike nutritional labels or health warnings, which are factual and aim to inform consumer decisions without entailing moral or subjective judgments, the Texas law's required rating could reflect or impose specific viewpoints about what is considered appropriate for children, which is a highly subjective and culturally sensitive area. What can educational administrators learn from this case? Educational administrators must recognize the broad implications of the First Amendment within the educational context, especially when considering policies or laws that may compel speech or restrict access to information. It is important to understand that policies influencing speech are subject to strict scrutiny. This reminds me of a case during the COVID pandemic. In that case, a school district had a mask mandate. A vendor went on social media to criticize the school district's COVID policies. The school district terminated the contract with the vendor. Can the school district do that? In that case, criticism of a public school district's policies generally falls under protected speech, given its public concern nature. But there was also a contractual relationship between the school district as a governmental entity and the vendor. Contracts typically include terms that both parties must adhere to, and those terms can sometimes include clauses about conduct that could harm the relationship or the reputation of either party. If a vendor violated those contractual terms, a school district may argue that termination of the contract is justified based on breach of contract rather than retaliation for free speech. The key takeaway for educational administrators is the need for a balanced approach that honors the First Amendment within the operational context of educational institutions and their external partnerships. Educational administrators are tasked with creating an environment that protects the diverse viewpoints in their communities. This means you should be vigilant about the potential for policies to inadvertently infringe on free speech rights. Your guiding principle should always be the promotion of an educational environment that values and protects free speech as well as encourages constructive criticism.